Welcome, everybody. I am Ginger McCallum, Chair of the Government Action Team of the League of Women Voters of Manatee County. I'd like to also introduce our President, Alice Newland. Give a little wave, Alice. Today's hot topic is ethics and local government. We will address the Florida Sunshine Law, the Public Records Law, and the Code of Ethics for elected officials in layman's terms, as well as discuss local issues with ethics and sunshine. The League of Women Voters, a nonpartisan political organization, encourages the informed and active participation of citizens in government, works to increase understanding of major public policy issues, and influences public policy through education and advocacy. This presentation is being recorded and will be posted on the League of Women Voters Manatee County website. During the presentations, please put any questions you have for the presenters in chat. Alice will be monitoring chat and questions will be posed after both presentations. Chat is only for questions for the presenters. Please, no comments or side conversations as it is distracting for both those attempting to listen and to the presenters. Florida's open government laws are widely regarded as some of the broadest and most all-encompassing in the country. Despite these broad requirements, Manatee and other counties in the state have been embroiled in controversy and lawsuits over purported violations of these laws. Today, we have two excellent speakers. The first will inform us as to what are the open government legal requirements. And second, we will hear from an individual dedicated to assuring open government for journalists and citizens. Our first speaker is Krista Storey, Esquire. Krista has served as a Florida local government attorney for 38 years at both the municipal and county level. She recently retired from her position as a senior assistant county attorney for Martin County and joined Emerald Law Firm as a partner. After working for 3 different local government entities, Krista has an exceptional understanding of the processes and procedures used by and required of local governments. During the course of her local government career, she has made numerous presentations on the Sunshine Law, the Public Records Law, and ethics to county and city employees and volunteers serving on local government boards and committees. Our second speaker today is Michael Barfield, Director of Public Access, Florida Center for Government Accountability. Michael focuses on the enforcement of open government laws and is a frequent lecturer on Florida's Public Records Act and Sunshine Law. Michael is the immediate past president of the ACLU of Florida. He is a life member of the Florida Association of Criminal Defense Lawyers and received the President's Extra Mile Award in 2008 for work related to indigent criminal defense. We'll start with Krista, and I'm going to share my screen and pull up a presentation.
Okay, are you ready for me to go? Okay, good afternoon, everyone. I'm very pleased to have been asked to make this presentation, and hopefully I can present it in a way that's understandable and meets the goal that was established for the presentation. So the topics as indicated, sunshine, public records, and ethics are all part of the open government, transparent government perspective in Florida. And so the presentation is broken up into 3 parts to talk about some of the basics, as well as provide some scenarios, and then we'll go from there. So the first part of the presentation is the Sunshine Law in a nutshell, is the characterization. So the first thing I would talk about will be the bare essentials of the law, and then to provide some illustrative scenarios that may be helpful for you to have a better understanding. So in terms of the bare essentials, and let me backdrop just a little bit, both the Sunshine Law and the Public Records Law are provisions that are embedded in the Florida Constitution as well as in Florida statutes. Section Article 1, Section 24 of the Florida Constitution gives the public the rights both for the sunshine, what we refer to as the Sunshine Law, as well as public records. And then there are different statutory provisions that provide the mechanism for further details. So having said that, the context here, particularly of the Sunshine Law, is the Sunshine Law applies equally to elected, appointed, and advisory boards and committees. It is generally not applicable to staff committees unless there have been certain delegations to the staff. And it is not applicable typically when there is just a fact-finding perspective on a particular entity. The Sunshine Law applies to any gathering of 2 or more members of the same board or committee that are gathered together to discuss any matter which will foreseeably come before that entity. So these are some of the things that you check off. 2 or more of the same board and a matter that may foreseeably come before that board. So before getting into those types of details, let's talk about the bare essentials and what is necessary for a meeting to occur and how for that meeting to be consistent with the legal requirements. So I think the next slide is probably applicable. So notice. So in order for a meeting to be a public meeting, and maybe this is just an overly simplistic, but the public has to be aware that the meeting is going to go on. So otherwise, how can it, you're saying, of course, it couldn't be a public meeting if it was held secretly. That's true. One of the things I always liked at this point to contrast is the difference between something that is meeting in the public, in the sunshine, contrast all this, the perspective of, and this goes back to years and decades ago, the closed door, smoke-filled room. And it's probably a statement of fact, not a characterization, where mostly they were men. Men behind closed doors making decisions for all of us. So that is the perspective of what we do not want to occur. And so the Sunshine Law brings you into modern times and the goal of public participation. So in terms of notice, a notice of a public meeting is a requirement before that meeting can occur. It's reasonable notice of the meeting. Notice of a public meeting does not mean that there has to be a publication in a newspaper. A newspaper publication of the meeting itself is not a statutory requirement. So things such as websites, agendas that are distributed and posted or made available at the front desk of if you have a governmental building or something such as that, or email lists or something such, those types of things, as long as that information is set forth in a reasonable time. Many jurisdictions, in terms of talking about, let's say, your county commission meetings, your city commission meetings, they may have other requirements for timeframes and all that. Those may be up above and beyond, but the statutory requirement is a reasonable notice that the meeting is going to occur with information as to when, what time it's going to start, the location, and those parameters. Now, the second piece of it that is embedded in the statute is that the meeting must be occurring in a public setting. So let me contrast that scenario and that requirement with one of my very early days as an assistant county attorney in a county that will not be named. It is not Martin County. And I was taking over representation of a certain board. And I was advised that they met in the back room of a restaurant in this particular small town. Well, the back room of a restaurant that you had to walk through the door of the restaurant. This was a place that served meals and may or may not have had accessible options in compliance with the ADA. It was just in the back room. Well, I did not make a lot of friends as a very young attorney representing that board, and said that location is not appropriate. That is not a public setting in the sense of accessible to the public who's entitled to see and hear and observe these types of meetings. So the public setting, I think jurisdictions, the jurisdiction I have been working at most recently uses governmental buildings, libraries, the administration building, community centers, or parks locations, all those types of things to make sure that there's sufficient room and there's access for the public to be able to get into the location and not feel intimidated about attending the meeting. That's a very important component of the statutory requirements. So the next requirement is minutes. Minutes must be generated to document the occurrence of this public meeting. Now, minutes are not defined in detail in the statute. And again, all of my comments are on the basis that if there are other rules and regulations and information that various jurisdictions have above and beyond this, then I'm not speaking about that. But minutes, the statutory requirement for minutes and the case law is that the minutes reflect what occurred, the important decisions that were made, potentially reflecting who may have spoken. The thing that I think that is often difficult for members of the public to understand is there is no requirement that the minutes be verbatim. The minutes are not required to reflect every single comment that went on in the meeting. I know oftentimes members of the public kind of are upset that their comments weren't reflected. They may be more generic. That's all acceptable under the law as long as the major components of the meeting were reflected, the attendance of the elected officials or advisory board members. That's all that's required under the law. So those are, I'd say in a nutshell, the bare essentials of the Sunshine Law. Maybe let's talk about some scenarios to illustrate how the law should work and how some of the case law decisions, and hopefully give you a better perspective of the workings of that. So I think that maybe the next slide. So I'm going to repeat again that the law has been deemed to apply to any gathering of 2 or more members of the same board to discuss any matter which will foreseeably come before the board. Let me highlight for you the fact that this is two members. Now, one of the things I think is important to distinguish the Florida law is that a gathering can constitute a meeting even though a quorum isn't present. Under the Sunshine Law, 2 or more members. Elected bodies tend to be 5, 7. Generally even advisory boards and committees, at least from a staff perspective, you try to have an odd number. So to make sure you can avoid ties generally, but looking at, let's say, a 5-member county commission, 3 members is a quorum. Under the Sunshine Law, though, the meeting requirements kick in if 2 or more members are gathering together to potentially discuss something that could foreseeably come before the full entity. That is a violation of the Sunshine Law for that to occur. For 2 members, existing members of the same elected body, advisory body, to meet outside of the eyes, ears of the public to talk about something that could foreseeably come before. The intent here is the public gets to see the dialogue, the conversations, gets to view what is transpiring in the doing of the public's business. So this illustrates 2 existing members of the same board or committee. Now, the Sunshine Law is also applicable if you may have new members, someone who's been elected. So, for example, we have elections upcoming. Once a person is elected and they have been deemed to have been elected, and even if their term has not started, that individual may not speak to another member of that body outside of the sunshine. That would constitute a meeting and be a violation. Now, in terms of what constitutes a meeting and how you could potentially overcome that and allow that to occur, if that entity has a mechanism where you could have a committee meeting or a subcommittee meeting or something, and you want to provide notice and in a public setting and allow that to transpire, then if all the elements of the law are complied with, those individuals are free to meet and discuss something that could foreseeably come before them as long as all those legal requirements are met. That doesn't typically happen when you have less than a quorum. So anyway, and maybe that's a good thing that doesn't occur. And you have some meeting outside of your normal meeting process. So anyway, so let's go into the next. Does the Sunshine Law apply to members of different boards or committees? No, it does not. We are talking about, you look at it on an entity by entity basis. For example, a county commissioner could meet with a local planning agency member, or I don't know, sometimes they're called planning or zoning or something like that. So county commissioner, one body, planning board member, another body. No, the Sunshine Law is not tripped into effectiveness by that occurring. So you have to sit on the same board or committee. Foreseeable matters. So it's important that the context, that we talk about the context of foreseeable matters, because the Sunshine Law does not prohibit people that are serving the public, either elected advisory boards or committees. It does not prohibit them from going to events, social events outside of their arena of their public service. So going to a social event and not speaking about anything that's related to what could foreseeably come before that entity is perfectly fine. So you don't have to always say, I recommend to my new board and committee members over the years, Just because you see somebody else that serves on your group, it doesn't mean you have to leave you don't have to leave the gathering, the holiday gathering. You don't have to walk out of your synagogue or your church or something just because that person's in the same room. Do you have to avoid having a conversation about something that could foreseeably come before you as an entity? Yes, you do. And given the nature of things, given the nature of the world we live in, that is a topic that should be people should be very cautious about it. So there will tell you kind of moving on. There are some exceptions, the types of two things that are required to be held in the public, in the sunshine. Certain things related to litigation, collective bargaining, those types of things do not, there are some exceptions in the statute and do not have to be held within the sunshine. So let's move on to public records. Public records, again, has a constitutional provision that is the basis for it, but then the statutory provision is in Chapter 119 of the Florida statutes. Public records, some of you may have made public records requests or considered public records requests. The law does not require such things as that the request be in writing. You don't have to identify who you are. Now, sometimes it makes it hard for your request to be filled if you don't want to say your name. If you have provided some other mechanism to get your records, you don't have to give a reason why you want the records. So however you can articulate your request, and within those parameters, calling up on the phone and just asking for public records is what's the bare minimum legal requirement. That doesn't mean that's going to facilitate your request and get you what you're looking for, but that is the law. The other thing it's important for the public to understand about public records, that means public records, documents, reports, emails, things that exist. A public records request is not the same thing as asking a question, asking for someone to create a response, such as, please provide me with X, Y, and Z. And if your jurisdiction does not have that already in a record, there's no obligation under the statute to provide that. Now, there's some subtleties about determining if that record exists and it doesn't exist in another format. And that is the reason why people that are making public records requests should be very specific, articulating what they're looking for. Requests that are too broad or not specific enough are probably going to be difficult to be responded to. Kind of dropping back to the very basics, under Florida, Chapter 119 Florida statutes, basically any piece of paper that you can find in a governmental building, unless it's specifically an exception, is a public record. There are some things that are exempt. There are certain things related to people's health and social security numbers and financial information. There's also a series of exemptions under the Florida statute, but the public can start from the perspective that those are the public's records, and generally what's in existence in a public building are records that the public could view. There are requirements in the statute for copying. If you want copies, these days, electronic transmission of records sometimes, then there's not necessarily, entities are doing that versus copying, that's fine. Those are all options. Generally, when I first started the practice of law back in the 80s, basically there was written documents. That was it. Today, you have texts, you have emails, you have voice messages, you have all these other ways to transmit information. If that information is being transmitted or it was created as part of the transaction of the official business of an agency, that constitutes a public record, and there's certain obligations to retaining those, maintaining those, providing those records to the public if the public requests. Again, I'm kind of taking a broad brush, but again, and there's been cases about elected officials texting during meetings to each other people. Those things, those are public records. And so technology has maybe been our friend and maybe not our friend in terms of the arena of the public records. The other thing, public records, there's real no exception for things that are drafts. It's not appropriate for someone to say, well, that's still in a draft form. If that record has been, if that document has been created and it's been shared with someone, it's not just one individual's document. For example, as a lawyer, if I was working on something and drafting something, if no one else saw it, then there could be an exception under the public records law for that. But once it's shown to someone else, and the point of that was to transmit that information, then that becomes a public record. So there's not an exception for work in progress generally. Those types of things. Once it's created, it's a public record, and generally, unless it's specifically exempt under certain other provisions of the law, it would have to be provided to the public if someone requested it. You cannot, one of the things I've seen in the past is advising staff people, well, I stamped that confidential, private. That is not an appropriate response, and that doesn't take that out of the context of a public record of a document that the public could be entitled to at least view, if not have a copy of it. Let me see. Let's maybe move on. So make sure I'm not, I'm a lawyer, and sometimes we just are over chatty, but let's go on to the ethics part of the presentation. So I think that people often think, familiar with public records and the sunshine, but to me, part of the open government transparency in Florida is there's a strong code of ethics for public officers and employees. And that is embedded in Chapter 112 of the Florida statutes. It covers public officers and employees. That's fairly broad. Not only these entities like advisory boards and committees we've been talking about, even at the local level, those people can be considered and often are public officers under this portion of the law and have some obligations in terms of how they behave. And their obligation for doing the public's business in the interest of the public and not for their own gain or the gain of someone else, or it's the context here is that public officers are going to conduct themselves independently and impartially. And that's the context of the Code of Ethics. Themes like not accepting gifts, not doing business with your agency, having conflicting employment, making sure your relative gets a job. All those types of things are covered under the Code of Ethics, with some fleshed out in great deal and some with lesser detail. One of the things I think that's important to talk about in terms of ethics is the issue of voting and when elected officials are required to vote and when they're required to abstain. And that is also that's covered in 112. The context in Florida law is if you are on a public body and you are sitting in the room, you are obligated to vote on that matter, unless there is a particular statutory requirement that you do not vote. And in Florida, generally speaking, the only time you can abstain from voting is if you have a financial conflict of interest. And Chapter 112 Florida statutes provides for an explanation of what that constitutes. So otherwise, you're obligated to vote. You're obligated to do the public's business as you were elected or appointed to do so, and you must do your job. You cannot refrain from voting just because you have a packed room and it looks like they're going to be ready to, say terrible things about you, and you won't be welcome in your neighborhood. You're obligated to vote, and there's statutory requirements for that.
Krista,
Yes, ma'am.
I'm sorry, is this a good time to kind of move on, or?
I'll just make one comment in terms of enforcing the ethics. There's the Commission on Ethics, there's statutory provisions, and that is all, that's how the Code of Ethics is enforced. So anyway, yep, no, I'm good.
All right, good. We'll come back to that in the questions.
Okay, sure.
Okay. So
if you do the last slide, it says on to Michael.
On to
Oh,
Michael. I know. I was just trying.
Sorry, I didn't follow directions. I apologize, Alice.
That's okay. I couldn't get the slide to move. Michael, are you ready? Unmute yourself and take it away on some of the issues that we're having locally regarding ethics and our elected and appointed officials.
Good afternoon, everyone. I'm just repositioning because I'm at the courthouse over in St. Lucie County about to go into a hearing. So I apologize that my background's a little bit boring. My name is Michael Barfield. I'm the Director of Public Access at the Florida Center for Government Accountability. And I wanted to tell you a little bit about what we do at the center. Predominantly, we aid reporters and citizens seeking access to public records and seeking to enforce Florida's open government.
Oh, no. He's just. We've just lost him. Not a good idea, Michael.
Alice, if you would text Michael, maybe we could, let me look at the chat and we will.
There are some questions that are specifically for.
Yeah.
Yeah.
Krista, just off, I have one off the top of my head to get us started while I review the chat is, how does a citizen file an ethics complaint? You were just starting to touch on that. And who can file an ethics complaint and how would they do that?
So through the Commission on Ethics, I will tell you that this is not particularly my area of expertise, but I just, in preparation for this, I kind of refamiliarized myself with the website for the Commission on Ethics. And there is actually a very good step-by-step approach, instructions and criteria and all that. So, but generally, someone who believes that someone has violated the Code of Ethics can file something. You've got to be prepared to substantiate your position as to that. But anyway, and those complaints for a period of time remain confidential.
Okay, thank you. So the first question we had in chat is there any successful way to push back against the sometimes egregious charges given before public records request will be fulfilled? And I assume that means sometimes they're pushing back on filling those requests. Stacy, if you want to, if I'm not getting that correct, if you want to.
I want to clarify. So sometimes they charge for the labor hours to pull the information together. And sometimes those calculations are so ridiculous. It's hard to wrap your head around because everything is electronic now. Therefore, how long could these searches actually take? Thank you.
Okay, I got you. Financial charges.
Okay, well, I think that, and I've worked as a staff person for an entity and seen, voluminous public records requests. So not disputing what your perspective is. it is often because of the breadth or the overbroad request, and the staff's obligated to try to respond to that. It may be labor intensive. The records may or may not all be electronic. And so, but it has to be reasonable. And there is some case law and I think statutory provisions that do limit, the kind of the chilling effect by saying that that's going to, it's going to cost $100 or $100,000. But one of the things, just from a perspective of a county attorney and files, one of the things is that for someone to go through our physical files, we need to have a staff person there in the room with the individual, because those records are important and we've got to maintain them. So there's different fact patterns. You're certainly asked the question about why, and the response may be, well, maybe narrow your request or explain. But there are some legitimate reasons why some of these records are more costly to obtain than others, I will say.
All right, thank you. There's a quick one, and then I'm going to go up to a more detailed one. The sunshine requirement of 2 or more people meeting in person, does that apply to a telephone conversation or a Zoom meeting?
Yes, you cannot circumvent the sunshine law telephonically, on Zoom, or even electronically. One of the things that could constitute a meeting is communication back and forth via email on people that serve on the same entity, discussing something that's going to be foreseeably come before that body. So it is very broad. Counseling elected officials and boards and committees, you have to be very, very conservative and do not put yourself in that position. So the public record could trap you into a violation of the sunshine law if you've been communicating outside of the public's view.
Okay, and that would apply to text as well, when they're communicating with each other via text.
Yes.
Even during a meeting.
Correct.
Okay.
Ginger,
Yes.
is it possible, I know that we've taken a few questions, but we cut Krista off on the ethics piece, and I think maybe
that was our first question.
Yeah, should we go back
we talked about that
and get a little more information about the ethics piece?
Sure.
Now that we've lost Michael.
Okay. I think probably I had covered most of it, other than kind of some of the specifics about the ethics law, which is kind of evolving, and I'm not an ethics expert, but let's, some of the specific things that I think are tripped, and maybe I've seen some, discussion, is that at what point is some kind of participation in a matter potentially an ethics violation? And you've got to look into the code, it's Chapter 112, Part 3, the Code of Ethics for Public Officers and Employees. And there's some very specific thou shalt nots. And the context here again is that the public's business should be being done by individuals for the benefit of the public, not for the benefit of someone else, not for their own benefit. The public needs to be able to trust that their best interests are being considered. The public, not an individual member of the public, not a property owner, not a homeowners association. So the Code of Ethics discusses what's the appropriate behavior and how public officials should conduct themselves. And it is enforced through the Commission on Ethics. People have different perspectives on that. I was reminding myself of history when violations of the ethics laws maybe were criminal, but now they're handled in an administrative process with a group, and there's the staff to investigate that so that they're there are a number of sides to the story. There isn't one of the things that is required under Florida law is disclosure of financial interests. Elected officials, certain people that serve on advisory boards and committees are required to provide annual disclosure of financial interests. I believe they're filed with the supervisors of elections, and there are penalties for not fulfilling that. And those are public records that the public would be able to get copies of and peruse. So,
Krista, are there examples? Are there examples of common ethics violations or some things you've seen in your work that maybe we should be aware of?
Well, first of all, one of the things I'll point out to you that the decisions of the Commission on Ethics, there's another thing is available on the websites. They have published decisions, and you can actually go on for some kind of, for example, if you're a person wanting to file an ethics complaint, you can go on and there's a, very easily accessible, get copies of those opinions that may help you as you are trying to sort through something, as well as give you some guidance about what may or may not be appropriate and what should be for an ethics opinion. I mean, voting conflicts are often a source of an issue, and someone who had some financial interest and they did or did not disclose it, and the ramifications of that. I think you're seeing conflicting employment or contractual relationships coming up, and the statute was recently, or there's some opinion recently that's kind of tightening what that means in terms of elected officials or other people who maybe have outside employment that may be potentially conflicting with their service. They've kind of been all over the map. I'm kind of beyond that, Ginger. I probably would not be, I'd just be kind of babbling in response to.
We
sorry.
do have, I believe we have Michael back, if we could get him to give us.
Hi, Michael, can you hear us?
We do not have a
Can
video.
you hear me?
Yes.
Do you have
Yeah,
a video?
I will
or?
try to turn it on to see if you can.
There you are.
Okay. We'll
All
try
right.
that again. My apologies. So what I was talking about is what the center does, and I did mention that we aid reporters and citizens in obtaining access to information. That's basically what we do. We have a journalism unit that also writes stories on records that we obtain ourselves from the government relating to, it could be a wide variety of things, from misappropriation of resources to what's going on with county commissioners. And the example with county commissioners in Manatee texting is a good example. We decided to file a lawsuit there because they weren't archiving the records as they are required to do. Krista mentioned text messages being a public record, and that's long been the law in Florida. And yet we found out that the county wasn't archiving or storing these records as they were required to do under the retention schedules. So we filed a lawsuit to compel them to perform the duty that they're required to by law. And that case is still pending. I think we will be amending the complaint soon to bring in additional information about the county neglecting its duties under Chapter 119. More recently, very recently, just this morning, we filed a lawsuit against the governor of Florida, Ron DeSantis, over his failure to produce records relating to the relocation of immigrants from San Antonio to Martha's Vineyard that I'm sure you all have heard about in the news. And to date, even though our records request was made several weeks ago, the governor's office hasn't produced a single record that we requested. And we felt that the public has a very vital interest in knowing what's going on about that incident. And that the public's right to know is more important than the governor's desire to dole out misinformation or piecemeal information that doesn't tell the whole story. So we are seeking to have a judge direct the governor to provide us with the actual records we requested. I do know that a lot of the media organizations nationwide and in Florida are joining in that action, and you'll probably be reading and hearing more about that later today. We've also challenged the Florida Department of Health in their denial of access to records relating to COVID-19 pandemic. And that case is pending in the First District Court of Appeal. The Department of Health lost at the trial court level on a preliminary hearing, and they have taken an appeal, and we're waiting for that ruling to come down any day now. So these are some examples of what we do, and it's vitally important that for what we are doing and how we are exercising the public's right to know, to have access to these records that the law allows us to have access to. And that goes for any citizen in the state of Florida. You don't have to have an interest in it. You don't have to be a resident of a particular county. If you want public records, the government has to turn them over to you with few and far exceptions. And Krista talked about exemptions, that information can be redacted, but generally speaking, the Public Records Act allows any citizen to get their hands on records, and if they don't provide them within a reasonable period of time, to go to court and ask a judge to compel their release. And if the judge makes a finding that the delay was unreasonable, or that the agency did not produce records, to award attorney's fees to the citizen or organization for having to go to court and fight for their right to know. So we think this work is vitally important to democracy in Florida. And it's somewhat ironic. I've been doing this a long time, 30 plus years, well before the digital era. And we used to get records without much fuss and a lot quicker did in the digital era. You would think it would be the converse of that, but that's not the case. We find that agencies are just very aggressive about denying records requests, citing excessive fees, delaying production, and giving citizens and journalists the runaround when it comes to the public's right to know. And so the center plays a vital role in leveling the playing field, so to speak, to make sure that the citizen and the journalist's interest in obtaining access to information and enforcing the Sunshine Law and Records Act is upheld and vindicated. After all, it is a constitutional right in Florida. We were the first state to elevate this right to constitutional status. And so we believe it's vitally important to a functioning democracy. And I'll stop and see if any questions.
So I'm going to go back up to a question that was posed earlier. I skipped over it a moment ago, but for a school advisory committee, the Sunshine Law applies, of course. If the principal and the chair are on that committee, of course, if they get together to talk about reasonable business, it's covered by Sunshine. What if they're just meeting to discuss the agenda? Is that constitute a public meeting, and should those minutes or recording, or should it be noticed? Should it fall under the law, or does it fall under the law?
Well, if I was advising those individuals, and they serve on the same committee, and I would advise that is problematic legally, because something could foreseeably come. That agenda, if you're discussing the agenda, I would assume that those topics could foreseeably come before. And to me, as a conservative approach, if those were my clients, I would suggest that, the chair meet with someone else, the staff level, who's not on the committee, if there are issues administratively regarding an agenda. So I think that's problematic, and it's quite frankly, I don't think it's worth it. I mean, to me, I think the public's business and people should be cautious, and it's appropriate to be cautious. So some of this is very conservative, but I will admit that because I believe in open government. And so anyway, that's my perspective.
Okay. Okay, thank you.
I will, one other thing I will add that I know in my in the jurisdiction I was in, recognizing these types of issues that make it difficult for staff to conduct, for the business of an entity to be done, looking at the structure of certain boards and committees, so you don't run into these issues, that you just have some administrative staff that then is sitting on a committee with an elected official or something, and you run into their problems, and it's just, it's not worth it. And there could be a different way to approach it. And, you know, because we have a broad sunshine law, very broad sunshine law.
Okay, thank you. Please, one of you address when an elected official or an appointed official has a nonprofit that they or a relative receives a salary from, and they get contributions from local developers, for example. Is this a violation of ethics or sunshine? So they've got some connection, their nonprofit has some connection to themselves or immediate family member, and they, as part of their campaign, I presume, are receiving election contributions from developers. Do I have that question correct? Does it make sense, Krista or Michael?
So the law prohibits someone from voting on a matter which would inure to a person's individual private gain or loss, or by an entity that you are employed by, or relative, or etc. So that's as to voting conflict. I mean, these types of matters are very fact specific. You know, campaign contributions, you know, individuals, I mean, members of the public make campaign contributions. You know,
okay, and I have a clarification, not election contributions directly to the commissioner's nonprofit. Okay, so the developer with whom a commissioner may have matters is making contributions to the nonprofit in support of that nonprofit's mission, but so the same, I would assume the same answer applies.
Yeah, it's you know, the details are very important, and you know, the issue is that the individual must be able to make a judgment on a matter that based on the facts before them, and not, you know, have some inability to be impartial. I mean, some of these things, quite frankly, should just be avoided, in my opinion, and that's not always, you know, people have to live in the world they live in, and lawyers sometimes, you know, are accused of not seeing the real picture. But some of these things, quite frankly, in my opinion, are not worth the issue of raising those concerns among the public, because it's kind of squishy. And that's probably, anyway, it might be a little concerning. I don't know if it's illegal, but the perspective, the appearance of impropriety and issues is often worse than the actual facts. And I don't know if Michael has a different perspective, but anyway.
Okay. And certainly a citizen, if they have that concern, could file an ethics complaint, and it would be reviewed by the commission.
Let's see if it amounts to something that's prohibited. Correct. Yeah.
Okay. Krista, how do these issues relate to the League of Women Voters Board or to a community homeowners board?
They don't apply at all. They do not apply unless those entities also have enacted things that are similar. So the sunshine public records are for public bodies. Public bodies, okay, meaning governmental entities, some state agencies, you know, they may apply to the executive branches of Florida. The legislature, there are the public records, sunshine, those do apply to the legislature generally, but there are some exceptions. There's different constitutional provisions in terms of what applies to the legislature. So, but they're not private entities. It doesn't apply to private entities.
I'm going to sneak in one last question because I think it's a very interesting one. If elected officials two or more are using Snapchat or another one of our modern communication mechanisms that disappear after a period of time, how does that impact our public records requests?
And maybe this is better for Michael, but they can't avoid the designation of a meeting because you use something that disappears. I mean, that's still, I would say that constitutes a meeting. Now, Michael, how you enforce that? I don't know.
I think we've lost Michael again.
I mean, one of the things, and I don't say this, I don't mean to be cute about it. If no one knows that the public records exist, it's kind of hard to assert it, but that I'm not advocating that using that alternative mechanism to communicate is appropriate. And there's an obligation to have that document so that the public can view it in whatever form, but it's problematic to enforce it. Correct. Yeah.
All right. Thank you. Well, on behalf of the League of Women Voters of Manatee County, I'd like to give a big thank you to Krista and to Michael for a very informative session. The recording of today's session will be posted on our website, lwvmanatee.org. And I would also like to take a moment to talk about election information sources. The League of Women Voters Voter Guide, vote411.org, is a nationwide effort to provide voters with the across the country, with the voting information that they need. You can get personalized comparisons of local candidates who are seeking your vote through our website and under election information, and also have printed guides going to county libraries, government buildings, and some community centers on Wednesday of this week. We're also doing presentations at Manatee County libraries on the constitutional amendments and local referendum, new voting requirements, and most common voting mistakes. All of these begin at 6 p.m. and remaining are Wednesday, October 12th at Braden River, Thursday, October 13th at Palmetto, Wednesday, October 19th on the island, Thursday, October 20th at the Central Library. And finally, I just want to thank everyone for joining us today. I hope you have a great afternoon.